I think one of the main questions that is usually raised is why the two organizations? And let me answer that by saying, first of all, it is historical. As I said, the French-speaking countries, when they got their independence, and you know how the French system was working, was very much centralized. They found themselves without any institutions dealing with intellectual property at the national level, because during the colonial time, intellectual property were dealt with by the National Institute of Industrial Property in Paris. When they got independence, they found themselves without any institution. And as in many other areas, you also know that they have even one currency. They decided on their side to have just one institution that is located in Cameroon, in Yaoundé. Their choice at that time, 1962, was to establish just one institution, centralize everything in the institution, have one law for the intellectual property, one set of administration. So if you want to protect your intellectual property rights in the OAPI jurisdiction, you only have one possibility, which is to go through OAPI. You don't have any other choice. That was their choice at that time. That was their decision. On the English-speaking countries side, and also, let me say, Portuguese-speaking countries, they were in National Intellectual Property Office already there. So the meetings that, the gatherings that then created the condition for the establishment of ARIPO that started around 1972, 1973, were based on the IP office that are now meeting to discuss what do we do. So historically, the way the two institutions were born was different. So one is historical, secondly is the language. So the OAPI focus on the English-speaking countries. Today it opened up, we have Guinea-Bissau, which is Portuguese, and the Equatorial Guinea, which is Spanish. But at its inception, it was really focusing on the English-speaking countries. ARIPO focused on the English-speaking countries at the beginning, but today we have also countries from other language origin or background, such as São Tomé and Mozambique, which are Portuguese-speaking countries, and the other countries like Rwanda, Somalia, Sudan, which have different connection with the past. Now, the two organizations are not only different because of the history and the language issues that I have highlighted, but they run two different systems, two different approaches in terms of intellectual property, especially registration. As I said, OAPI runs a unitary system. A unitary system means that when you apply for an intellectual property rights at OAPI, everything is dealt with in the headquarters. And when the right is granted, it is automatically valid in all the countries. So you don't choose in which countries you want to be protected. The ARIPO system is based on the designation system, meaning in the case of ARIPO, when you apply for your right, for your protection in this route, you will then specify in which countries you want to be protected. So even if you take the case of the Harare Protocol, the protection of patents, which covers all the countries, the users, they choose some countries, usually between 11 to 12 countries. That's what we have seen as a trend. So they are not interested in all the countries. So this is what has been ensuing. So those are the main difference between the two organizations. But then in terms of relationship between ARIPO and OAPI, let us be clear about this. We are covering different jurisdictions, different countries. The two organizations are not competing. The two organizations cover two different jurisdictions. Now, we came together to say, we are two regional organizations. We serve the continent, and we would like to serve all the African continent if it was possible. How can we streamline our activities and improve our relationship? So we've been working together indeed for some time now. And since 2017, more or less, we have established a permanent forum, which is a committee, a joint committee that meets once every year. And in that joint committee, we discuss how best we can collaborate But most importantly, we are now working more in looking at how can we harmonize our system so that they are similar. Because we receive, of course, a lot of requests from users. How can they be able to file for applications in one side and get them recognized on the other side? So we know that there is this need in the continent. So we are really working on those issues together. Okay. Let me highlight a very important development also that happened 1 year ago, which is that in our collaboration, we also worked closely with the WIPO, and we signed in 2018 a tripartite agreement. It's called the WAO, meaning WIPO, ARIPO, and OAPI. And the idea here is to streamline the technical assistance for the African continent, especially the one coming from WIPO. And we meet regularly, we discuss continuously on joint activities. So whatever WIPO does in Africa, they coordinate that with both OAPI and ARIPO through this new platform, which is WAO. A flagship initiative that we undertook was last year, where we had this conference that was organized in Harare. In that conference, we came together. We had some more than 200 people who attended this this meeting. It was called the WIPO WAO Conference on Innovation, Intellectual Property, and Value Addition for Business Competitiveness in Africa. We really had the whole continent in Harare in that conference, including delegates from Nigeria. So as you can see, our effort is to work together. ARIPO and OAPI.